And we are live this morning as Justice Department officials are here on Capitol Hill to testify at a Senate Judiciary Committee hearing on foreign agent registration requirements. Recently, Senate Judiciary Chair Chuck Grassley wrote to Deputy Attorney General Rod Rosenstein over concerns about the Foreign Agents Registration Act as it relates to last year's election. The Foreign Agents Registration Act requires U.S. agents representing the interests of foreign powers to disclose their relationships with the foreign governments and information about related activities and finances. It should start in just a moment. Live coverage here on C-SPAN 3.
Today, the committee will examine the Justice Department's enforcement of the Foreign Agents Registration Act. I want to thank the witnesses here today for working with the committee to schedule this hearing. I know that some of you even had to change your travel plans, and I want you to know that the committee appreciates your cooperation. We had to postpone this hearing while trying to schedule 2 new witnesses and obtain the cooperation of a third who was first invited on July the 5th. It is unfortunate when uncooperative witnesses cause unnecessary inconvenience for those of you who are easy to work with. After he failed to negotiate with the committee in good faith, I issued a subpoena in the cooperation with Senator Feinstein to Glenn Simpson for his appearance today. I withdrew the subpoena after Mr. Simpson agreed to a transcribed staff interview about, number 1, his involvement in creating the Trump dossier and interactions with the FBI, and number 2, his alleged work with the unregistered foreign agents who met with the Trump family and campaign officials. Regarding Mr. Manafort, negotiations for a similar agreement that Ranking Member Feinstein and I were working on with him broke down Monday night, and I issued a subpoena for his appearance. On Tuesday night, following consultation with the Ranking Member and a document production from Mr. Manafort, I withdrew the subpoena, and we continue negotiations for a future transcribed interview. With respect to Mr. Trump, he agreed early on to cooperate, produce documents, and do a voluntary transcribed interview, so no subpoena was necessary in that case. So these 3 then will not appear on panel 2 today. Now today's topic is as important now as it was in 1938 when Congress enacted the law. There are 2 qualifications to be considered a foreign agent under the Foreign Agents Registration Act. The first is working directly or indirectly for a foreign principal. A foreign principal can be a foreign government, political party, corporation, or a single individual. The second requirement is involvement in a political activity to influence U.S. policy, either as a publicity agent or a lobbyist, among others. The basic idea is that a foreign propaganda should not lurk in the shadows, but should be fully transparent. The Foreign Agents Registration Act does that by requiring agents to register with the Justice Department. People should know if foreign governments, political parties, or other foreign interests are trying to influence U.S. policy or public opinion. Given recent Russian and other efforts to influence our elections, this law has never been more important. Unfortunately, it appears that the Justice Department and the FBI have been seriously lax in enforcing the Foreign Agents Registration Act, and for a long time. In the past 12 years, the department has only sent 178 letters to people it believes should register as a foreign agent. That's only 15 letters a year. Now compare those 15 letters with what the Justice Department thinks that I send more. They happen to think that I send more oversight letters than that in 1 week. Only 9 people in the entire Justice Department work full-time to enforce this law and monitor potential unregistered foreign agents. It's no surprise, then, that only 400 foreign agents are currently registered. Does anyone here seriously think that only 400 people in the whole United States take foreign money for PR and lobbying work? The Inspector General said the FBI investigators and the Justice Department officials can't even agree on what makes a good case for enforcement of this law. It is then no surprise that the Inspector General found that there is no, quote, comprehensive department enforcement strategy on FARA. That's the acronym for the law. End of quote. Between 1966 and 2017, the Justice Department brought only 7 criminal FARA cases. So listen to this. It has been 26 years since the Justice Department used civil injunction relief to enforce this law. Now, then, why comply when the Justice Department clearly doesn't treat this law as a priority? In an April 2015 letter to then Attorney General Holder, I wrote about Sidney Blumenthal's efforts to influence U.S. policy by leveraging his close relationship with Secretary Clinton. News articles reported that Mr. Blumenthal transmitted documents to Secretary Clinton on behalf of a political party in the country of Georgia. The Justice Department never explained why it did not require Mr. Blumenthal to register under FARA. If the Justice Department thought Mr. Blumenthal's activities on behalf of foreign interests did not require registration, it should simply say so, particularly when the Trump administration has required Lieutenant General Michael Flynn to retroactively register under the law, in a large part because he wrote an op-ed for the Hill newspaper. The administration also required Paul Manafort, the Podesta Group, Mercury LLC, to register for their work on behalf of the Ukrainian government. Recently, there's been a lot of reporting about other unregistered foreign agents attempting to influence U.S. policy. For example, a group of unregistered Russian agents allegedly worked to undermine the Magnitsky Act. That 2012 act was passed in honor of Sergei Magnitsky, who uncovered massive financial fraud in Russia involving corrupt Russian government officials and organized crime. He was then arrested by the same corrupt officials and later died in Russian prison under suspicious circumstances. The Magnitsky Act allows president to sanction individual Russian human rights abusers and freeze their assets in the U.S. The law was passed due to a tireless effort of William Browder, who will testify here today. Mr. Magnitsky was Mr. Browder's lawyer and friend. In 2016, Mr. Browder filed a complaint with the Justice Department's FARA enforcement unit. He alleged that a group of unregistered agents were working on behalf of the Russian government to get rid of the law named after his late friend. He said these unregistered agents lobbied Congress. He said they organized a screening of a propaganda video with Hill staffers and State Department officials. The propaganda video smeared Mr. Magnitsky and Mr. Browder. What this video represents is a pretty cute operation. The foreign agents also published propaganda to news outlets, trying to get bogus stories published by respectable organizations. As we learned after this hearing was scheduled, they apparently even lobbied the Trump campaign and the Trump family. Yet the Justice Department didn't require any of them to register as foreign agents. One individual identified as Mr. Browder's complaint is Glenn Simpson, founder of Fusion GPS. Since March 2017, I've been asking about the Russians who were working with Fusion GPS to smear Mr. Browder and undermine the Magnitsky Act. Mr. Simpson's company, Fusion GPS, is the same firm that oversaw the creation of the unverified Trump dossier. Around the same time, Fusion also helped orchestrate a campaign to repeal the Magnitsky Act for the benefit of Russian governments. There are public reports that the FBI used the dossier to kickstart its Russian investigation. Did the FBI know that Fusion pitched propaganda for the Russians even as it pushed the dossier? What would they say about its reliability? If the dossier was represented to any court, should this fact have been disclosed? Two other individuals identified in Mr. Browder's complaint have been in the news a lot lately. The first is a Russian lawyer who represents Prevezon Holdings. Her name, Natalia Vesnitskaya, as you know. We'll just refer to her as Russian agent XYZ or something. Prevezon is a Russian company that received millions of dollars connected to crime for Mr. Magnitsky's uncovering. The other person is Rinat Ometshin. He is a Russian-American lobbyist with reported ties to Russian intelligence. The New York Times recently described him as, quote, a master of the dark arts, end of quote. These two were reportedly at the meeting with the Trump campaign and family members last summer. They reportedly offered dirt on the opponent to get a meeting and then made their pitch against the Magnitsky Act. Was it just a clumsy bait and switch effort in their unregistered propaganda campaign? Hopefully we'll get some answers from Mr. Trump and Mr. Manafort on that point. We will also pursue details about Mr. Simpson's role in this event and the creation and circulation of the dossier that started this whole controversy. Knowing exactly who is acting on behalf of the Russian government is vital to get to the bottom of the Russian influence in our democratic system. That is why FARA must be enforced consistently and even-handedly. Other words, it won't be taken seriously. I look forward to discussing with the witnesses additional steps to better enforce FARA. And now it's my pleasure to turn the table over to my ranking member.
Thank you very much, Mr. Chairman. Let me just begin with a comment. Thank you for bringing everybody up to date on our discussion on the witnesses that were on the schedule here but are not at the present time. I think that's very helpful.
Sure.
So thank you. Ladies and gentlemen, the Foreign Agents Registration Act, or what our chairman correctly said is called FARA, is really an important issue, particularly at a time when we face unprecedented interference in our democratic processes by a certain country, namely Russia. FARA was enacted in 1938. That's a long time ago. It was enacted to ensure that the public was aware of efforts by the German government and the Nazi Party to use a network of United States citizens and firms to sway public opinion and United States policy in Germany's favor. The law requires any individual working on behalf of a foreign government or foreign interests to register with the Department of Justice. It doesn't prohibit lobbying or other political activities, but instead it requires disclosure when those activities are directed by foreign interests. Long overlooked, FARA has received renewed attention in the past several months because of the high-profile cases involving former National Security Advisor Michael Flynn, who registered retroactively for work that he had done for the Turkish government at the same time he was advising the Trump campaign. Former campaign manager Paul Manafort also registered in 2017 for nearly $17 million for lobbying work on behalf of the pro-Russian Party of Regions in Ukraine between 2012 and 2014. Unfortunately, late registrations under FARA are not a new problem, nor are they limited to these two examples. In September of 2016, the Justice Department IG reported that 62% of the registrations that it had reviewed had been filed late. 50% were incomplete. I'll let you draw your conclusions from that. My conclusion is that our authorities don't take the law seriously, and we need to change that. There appears to be no meaningful penalty for late or incomplete filings, and over the past 50 years, the Justice Department has prosecuted only 7 FARA cases. Instead, where violations are discovered, the Department encourages compliance, creating a system where there are no consequences for failing to follow the law. So I look forward to hearing from our witnesses today about whether and if what changes should be made and whether the current law is adequate. So once again, I thank you for solving our problems with the other witnesses, and I look forward to the testimony. Thank you, Mr. Chairman.
Well, besides your thanking me, you've been very cooperative, and I appreciate it very much.
Thank you.
I'm going to introduce the witnesses, and then I'm going to ask you to stand and be sworn. Adam Hickey is Deputy Attorney General for National Security Division, DOJ. He manages the National Security Division's efforts to combat national security threats. From 2013 to 15, Mr. Hickey was the acting Deputy Chief of Cyber for the Counterintelligence and Export Control section of the National Security Division. Mr. Hickey was also a federal prosecutor. Thank you for being here. So, Priestap is a assistant director for the Counterintelligence Division at the FBI. He previously served as Deputy Assistant Director of Intelligence Operations Branch in the Directorate of Intelligence at FBI headquarters. He has worked at the FBI since 1998. Thank you for being here. Michael Horowitz has been a frequent witness before our committee, is an Inspector General for the Justice Department. He was confirmed April 2012 and oversees a nationwide workforce of more than 400 employees. Immediately preceding this post, he was in private practice and also previously worked for the Justice Department's Criminal Division. The Inspector General's mission is to detect and deter waste, fraud, abuse, and misconduct. It's his mission to also promote economy and efficiency in the Department of Justice. We thank you for being here, and would you stand now at this point so I can ask you to, do you affirm that the testimony that you're about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God? They all affirm. Mr. Hickey, would you start out, and then we'll go to Mr. Priestap, and then to Mr. Horowitz. And then we'll have 5-minute rounds for questioning.
Good morning, Chairman Grassley, Ranking Member Feinstein, and distinguished members of the committee. Thank you for providing me the opportunity to testify on behalf of the Department of Justice concerning the Foreign Agents Registration Act. The Department appreciates the committee's interest in FARA. I know the committee already has my written testimony, so I won't repeat it here. Instead, I'll cover a few key points about the law and its background, how we enforce and administer it, and how the Department has responded to last year's report by the Justice Department's Inspector General. FARA is a disclosure statute that requires persons in the United States who engage in specified activities as agents of foreign principals to register with the Department. The Act's purpose is to ensure that the American public and our lawmakers know the source of information that is provided at the behest of a foreign principal, where that information may be intended to influence U.S. public opinion, policy, or laws. The statute defines who must register with the Department as a foreign agent and what they must disclose. It exempts certain types of foreign agents from the registration requirements, and among other things, it requires registered agents to preserve their books and records and make them available for inspection. Because FARA is designed to encourage transparency in public speech and political activities, not to discourage that speech and activities, it differs somewhat from other provisions of the criminal code, such as those that punish espionage and other clandestine conduct. Instead of prosecution, the primary means of achieving that transparency is by encouraging voluntary disclosure in compliance with the Act. The Department will, of course, approve criminal prosecutions under FARA if there is sufficient admissible evidence of a willful violation of the statute. But the high burden of proving willfulness, difficulties in proving direction or control by a foreign principal, and exemptions available under the statute make criminal prosecution for FARA violations challenging. Despite these challenges, however, the Department has brought 4 FARA criminal cases since 2007, all of which resulted in convictions. Day-to-day administration and enforcement of FARA is handled by DOJ National Security Division's FARA unit. A regular part of the FARA unit's work involves attempting to identify persons who may be subject to FARA but have not registered. The FARA unit relies on publicly available information and referrals or information provided by other government offices. If credible information suggests that the individual should register under FARA, the FARA unit will send an individual a letter advising them of the possible registration obligation and requesting a response. If the individual does not respond, or the response seems incomplete or untruthful, we will follow up. And in some cases, we may decide that a criminal investigation is appropriate and involve the FBI. Often, the recipients of those letters of inquiry will register. FARA unit staff carefully review registration filings for deficiencies, seek amendments, and conduct inspections to ensure continued compliance. FARA unit staff also provide advisory opinions regarding the application and requirements of the Act and perform other tasks that I've described in more detail in my written testimony. I will now address how NSD has responded to the September 2016 report of the Inspector General. The OIG report made 14 recommendations. NSD agreed with all of them, has implemented most of them, and is working to implement the few that remain. As a result, in February 2017, the OIG informed NSD that 6 of the recommendations were closed. NSD plans to file its next progress report in August, at which time we anticipate that the OIG will be in a position to close nearly all of their remaining recommendations. I want to thank the committee again for providing me this opportunity to discuss these important issues, and I'm happy to answer any questions you may have.
You bet. Mr. Preset.
Chairman Grassley, Ranking Member Feinstein, and members of the committee, thank you for the opportunity to appear before you. My statement for the record has been submitted, so rather than restating it, I'd like to explain why the issue before us is so important. The Foreign Agents Registration Act, or FARA, is critical because we need all available tools to combat today's counterintelligence threat. Unbeknownst to many Americans, the threat posed by our foreign adversaries is growing, both in volume and complexity. Our country is under relentless assault by hostile state actors and their proxies, and adversarial nations aren't just using their intelligence services to conduct these assaults. They are using a whole-of-government approach, pursuing their goals on economic, technological, military, diplomatic, and intelligence fronts. They use people from across their governments and from all walks of life in pursuit of their desire to gain strategic advantage over the United States in whatever ways they can. A lack of understanding of the scope and scale of the counterintelligence threat, combined with the fact the threat is a gradual one, leads too many people to underestimate it. But make no mistake, our economy, our national security, and our way of life are being actively threatened by state actors and their proxies today and every day. As just one example of this, a number of our adversaries engage in activities designed to influence U.S. public opinion, policy, and laws. By requiring these activities to be conducted in an overt manner, by requiring foreign agents to publicly disclose their relationship with foreign principals, the American public and the U.S. government can better evaluate the information these agents provide. However, when foreign agents don't disclose their relationship with their foreign principals, we are more susceptible to being unduly influenced. This is why foreign agents who willfully fail to disclose their relationship with foreign principals may be criminally charged pursuant to FARA. We live in an age in which we are bombarded with information, and so it's more important than ever that we understand its source. Otherwise, we can't fully understand and evaluate it. FARA matters because it requires foreign agents to publicly disclose for whom they speak. FARA also matters because in the counterintelligence realm, the United States needs every weapon in its arsenal.
It's really urgent.
While the FBI is the lead domestic counterintelligence agency, the only way to effectively combat whole-of-government threats is through whole-of-government responses. The FBI is committed to working with the Department of Justice to enforce FARA and any other statute that can be used against our adversaries. The FBI is equally committed to working with other U.S. government components, the private sector, and foreign partners to do the same. In closing, thank you very much for holding this hearing, as doing so raises awareness of the counterintelligence threat and one of the tools that can be used to fight it.
Thank you. Now, Mr. Horowitz.
Thank you, Mr. Chairman, Ranking Member Feinstein, members of the committee. Thank you for inviting me to testify at today's hearing. The Foreign Agent Registrations Act is an important statute that Congress passed to ensure that the people of the United States are informed of attempts by foreign principals to influence U.S. public opinion, policy, and laws. In September 2016, my office issued an audit report on the Department's efforts to enforce FARA and its administration and monitoring of FARA registrations. We found that the number of FARA registrations has declined significantly over the last 2 decades, and that criminal prosecutions and civil enforcement actions are rare. Additionally, we determined that over half of the initial FARA registrations we reviewed were untimely, and that 50% of registrants filed at least one recurring 6-month supplemental registration late. In light of the information we reviewed and evaluated, we identified 4 general areas of concern. First, the Department lacked a comprehensive enforcement strategy for FARA, and we heard about significant disagreements between the National Security Division, the FBI, and assistant U.S. attorneys about how such investigations were being handled and reviewed. Second, the National Security Division was having difficulty gathering the necessary information so that it could identify when foreign agents had failed to register as required under FARA. Third, the National Security Division needed to improve its monitoring and oversight of registrants, including ensuring that registrants were complying with applicable filing requirements and doing so in a timely manner. And fourth, the Department had not made an assessment of the reason for the sharp decline in FARA registrations over the past 2 decades including the impact of the Lobbying Disclosure Act exemption and whether any legislative changes should be sought. As a result of our findings, we made 14 recommendations to the Department, and they agreed with all of them. 5 of our recommendations related to enforcement efforts. Since our report was released, NSD has taken sufficient actions for the OIG to close. The 3 recommendations related to updating training for investigators and prosecutors, providing more timely communication with FBI agents and federal prosecutors on the NSD decision-making process, and working with the FBI regarding classification codes for FARA and Section 951 cases. Our recommendations that the NSD develop a comprehensive enforcement strategy and better track FARA cases remain open, although we're told by NSD that it is working to address those 2 recommendations. 7 of our 14 recommendations related to improving NSD's oversight of its foreign agent registrations. 2 recommendations have since been closed because the NSD has begun posting anonymized advisory opinions on its FARA website and because it has expanded its sources of information that it collects so that it can better gather information on possible foreign registrants. The other 5 recommendations remain open and address delinquency notices to registrants that have not filed documentation timely, the tracking of file closures, resolution of inspection reports, filing fees, and the use of its email system, the file system, to address timeliness. We've been told by NSD that it is working on each of those items as well. Finally, we made 2 recommendations related to possible legislative changes that we heard about. The first, which is now closed, related to the statutory 48-hour time limit for agent filing of informational materials with the Department, which our report found was not being met. To address this recommendation, NSD told us that it is seeking to amend the statute to lengthen the time period for agents to file information with the Department. Our other recommendation that remains open was for the Department to conduct a formal assessment of the impact of the Foreign Disclosure Lobbying Act on FARA enforcement and whether changes should be sought legislatively. We've been told by NSD that it is continuing its assessment of that issue. As to each of these 8 remaining open recommendations, my office will continue to monitor the Department's progress to ensure that they are fully implemented, because we believe they will further one of the primary goals that Congress had in passing FARA, namely greater transparency for the public about efforts by foreign principals to influence public opinion and public policy. This concludes my prepared statement. I would be happy to answer any questions the committee may have.
I think all the members know that the 2-hour rule's been imposed, so that means we've got to get through this panel and the next panel in an hour and a half. So anything that anybody can do to shorten their questioning period would be helpful, because one of our witnesses came from out of the country to testify.
Mr. Chairman, may I ask, do we know who's invoked the 2-hour rule? I find it hard to believe any United States senator would block our ability to inquire into this important subject. Do we happen to know?
I do not know.
Well, I hope some members of the press find out and ask why they would want to block this important hearing.
Yeah. We'll have 5-minute rounds. I'll try to cut mine short if I can to get to questions. According to the Inspector General, so I'm going to Mr. Hickey, Main Justice and the FBI are not adequately communicating with each other and have struggled to understand what qualifies as a proper FARA charge. Since 1966, the Justice Department has only brought 7 criminal FARA cases in which only 1 resulted in conviction and 2 pled guilty. So why would DOJ expect people to register and to be transparent when they aren't really punished for failing to register?
Thank you, Mr. Chairman. Let me begin by saying how appreciative I am both of this hearing and the members for holding it, and also to the Inspector General for his report. I took my current position about a year ago, and that is the first time I became responsible for the FARA unit. And it's very helpful when you take on a new position to have a roadmap of someone's put together for you, that issue spots where you need to focus, problems that need to be addressed. And so let me express my gratitude here publicly for the Inspector General for that report. As the IG's report lays out, I think there may be an element of a terminology misunderstanding in some parts of the Bureau and the Justice Department, which we are trying to rectify, which is that I think many agents and prosecutors refer to a different provision of the criminal code, namely Section 951 of Title 18, which also has the words agent and foreign government in its title, as FARA, instead of referring to the act that we're discussing today. I don't think, at least sitting here today, based on the work we've done over the last year, there is a misunderstanding. We worked hard to train prosecutors and agents in the field what FARA looks like, what a FARA violation looks like, and to bring cases to us. And in recent memory, I'm aware of only a single case in which a U.S. Attorney's Office has proposed a criminal charge that NSD has not approved, but that case was prosecuted under a different statute and a conviction obtained. So I think we have made great progress towards educating our field on the importance of these cases and the need to bring them.
Thank you. Now to Mr. Horowitz. Have the Justice Department and the FBI adequately addressed how FARA fits into the department's overall national security efforts? If so, explain, and if not, please explain what else must be done.
Well, we have not closed our recommendation regarding the need for a comprehensive strategy. We're looking forward to the August update that we are due from NSD about that. And our review highlighted this disconnect and the lack of a comprehensive strategy, both based on our discussions with assistant U.S. attorneys, FBI agents handling these cases, as well as the National Security Division folks, because not only were there the disagreements about the number of cases and what classification they fell in and which were FARA cases and which were not, but the absence of prosecutions and the absence of records to see what had happened with reviews that we heard complaints about.
Okay. Mr. Hickey, leading into your next two questions, I'm going to ask you, the department recently required the Podesta Group and Mercury LLC to register for engaging in public relations campaigns to benefit a foreign government. Public reports show that a foreign-controlled company hired Fusion GPS and Glenn Simpson to do propaganda work in an effort to repeal the Magnitsky Act. Fusion GPS reportedly dug up dirt on Mr. Browder's property and finances and helped generate negative news about him and his company. This covert negative publicity campaign would principally benefit the Russian government. So without reference to that particular case, if a company engages in a publicity campaign on behalf of a foreign government to influence U.S. law, does that generally create an obligation to register under FARA?
I'll get the hang of it. Thank you, Senator, for the question, and thank you also for acknowledging my inability to comment on particular investigations or potential investigations today. Let me describe our practice. Where we see credible information to believe that someone is acting as an agent of a foreign principal, we face a choice at that moment. In most cases, we don't have indications of willfulness, meaning we don't have indications that the individual is deliberately choosing not to register but aware of their obligation. And in that case, we would send a letter of inquiry and solicit more information. However, if we had indications that the agent was acting willfully, it may be more appropriate to go directly to a criminal investigation. I think in your question, sir, you used the terms on behalf of. I think I want to be precise. The statute applies to agents, so those who are working at the direction or control of a foreign principal. One of the challenges we sometimes face is that independent groups may have interests that overlap with or coincide with foreign governments, and that can be a challenge to our determination that they are acting at the direction or control of the foreign principal.
Senator Feinstein.
Thanks very much, Mr. Chairman. Mr. Horowitz, you've always been a straight shooter, and that's very much appreciated. I've been reading your remarks, bottom of page 3 and top of page 4, where you have a number of recommendations.
Yes.
And you begin by saying NSD officials told us they have difficulty compelling the production of information from persons who may be agents, and therefore NSD was pursuing civil investigative demand authority from Congress excuse me, to help enhance the NSD's ability to assess the need for potential agents to register. And you go on and you talk about including controls and oversight, and you also speak about ensuring the statutory 48-hour time limit for agent filing of informational materials. I think it's pretty clear that we need some legislation in this area. Would you be prepared to work with us on a bipartisan basis to strengthen this?
Absolutely. And I think my folks who did the audit have a fair amount of understanding now about where some of the fault lines are here.
Could you just sort of prioritize, if you were us, where you would go first, second, and third?
I think first and foremost is what you and the chairman have identified, which is putting some teeth into the statute and making sure that the FBI, the National Security Division, and AUSAs around the country believe they have the tools to ensure that people voluntarily comply. It shouldn't be the case that you're found about through Google searches or otherwise, told to register, and then you register. If there are no consequences to registering, why not wait for the knock on the door rather than come up voluntarily and do it? So I think that's first and foremost. Second, obviously, to do that, prosecutors and agents need to be able to get the information to see who isn't voluntarily complying. And that's where the civil investigative demand comes in. And I think then third, it's the question that has been raised and we talk about in our audit about the impact of the Lobbying Disclosure Act. What we heard over and over again was that the exemption in FARA for folks who are complying with the Lobbying Disclosure Act has impacted and is a major reason why there's been a substantial drop over the last 2 decades in the number of filings. The problem that we had when we went in to see if that was true is that the department wasn't tracking information and didn't know, in fact, if that was true. It was a supposition, but it wasn't, there weren't records to show it. So I would suggest those are the 3 areas where we should first and foremost focus.
Just a comment. I don't know a time when the United States feels more invaded. And by this I mean 21 states' election systems were pierced in this last election, we believe, by Russia. And that's a pretty sovereign interference, an interference with our sovereignty. So there are 2 of us here that serve on the Intelligence Committee, so we know some of these things. And it seems to me that the time has really come to tighten this act up, to know who's in the country, to see that they formally apply, to see that if they violate, it's prosecuted, and that it has become a priority for us. Would you agree with that?
Absolutely.
Gentlemen, do you have a comment to make on what I just said?
Senator, thank you for asking what other tools we might require. I'm aware of at least 2 proposals, I think, one that may have been introduced for legislative changes, and we are working hard to coordinate views across the administration on those proposals, and I, too, in the department look forward to working with Congress on this important question.
Well, can you give us the name of the legislation so we can find it?
I know that Senator Shaheen has introduced one bill.
Okay.
There is another bill in the House. To be candid, I'm not sure if it has been introduced publicly, so I don't want to exceed my writ today, and I've heard talk of other potential bills, but I know of 2 that we're working on right now.
Thank you, and we'll talk with Mr. Horowitz and you. Thank you, Mr. Chairman.
Senator Hatch.
Well, welcome to the committee. We're happy to have all of you here, and I come to this hearing with one simple message. Let's be fair. Let's judge both sides of the political divide, both parties, by the same standards. And there are a few things that I take more seriously than the allegations of foreign interference in the 2016 election. Actually, for foreign influence, foreign influence would be an egregious violation of our sovereignty. Even the plausible allegation of it can, if left unaddressed, seriously undermine public confidence in our institutions. Now, we've heard some pretty serious accusations of foreign influence over the Trump campaign, for instance, whether here in the Senate or in the or in the media. And frankly, many of these allegations have been truly outlandish. Most have been politically motivated, and all have been taking their toll. Even the most outrageous accusation, repeated often enough, will slowly acquire a false ring of truth, especially in today's media environment. And so to the extent there is anything to these allegations, Republicans are stepping up. There are investigations underway by both the House and the Senate Intelligence Committees. Before the appointment of special counsel by the Department of Justice, the House Oversight Committee was investigating. And now the Senate Judiciary Committee is investigating. All are controlled by Republicans. So I don't want to hear anyone complain that we aren't standing up and doing what is necessary here to get to the bottom of these things. As to today's hearing, a critical part of the investigation in this committee will be the application of the Foreign Agents Registration Act. It's a critical part of the equation. I want to commend Chairman Grassley and the ranking member as well for holding this hearing and leading the way on this. But I also want everyone, the media, the Democrats, our constituents, and Republicans to hear me and to hear me clearly. While these allegations may be too serious to ignore, they are also too serious to be left incomplete and too serious to be used for partisan ends. If we're going to get to the bottom of this, we need to investigate the whole story. That means looking at more than just foreign influence over the Trump campaign. It includes looking at serious allegations of foreign influence over the Clinton campaign and the Democratic National Committee as well. After all, if this national controversy is going to be brought to any legitimate conclusion, we have to treat it as more than just fodder for partisan gamesmanship and more than a headline-grabbing attack on the president. We need to explore both sides of the story. According to the committee staff report, and as numerous reports in the media have revealed, there are serious questions about whether foreign actors wanted to hurt, not help, the Trump campaign. And there are serious questions about whether foreign actors wanted to help, not hurt, the Clinton campaign. Many suspect that foreign actors wanted to help neither campaign, but they wanted to hurt our electoral process as a whole by sowing chaos and confusion. And so there are questions this committee needs answered. I'm pleased that the Trump campaign individuals have agreed to be interviewed, but it doesn't end with them. Fusion GPS, for instance, the opposition research firm, has a lot of questions to answer. The Democrat National Committee has questions to answer. And the Clinton campaign has questions to answer. So in conclusion, we have heard Democrats level grave, often outlandish accusations at the Trump administration and family. We've seen the media pursue it relentlessly, but we've heard far less about the rest of the story. Now, Mr. Chairman, I applaud you and the ranking member for scheduling this hearing. And I implore my Democratic colleagues in the media to join me to join the Judiciary Committee in getting to the bottom of this. We must ensure that these investigations serve as an opportunity to protect our institutions, not merely as an excuse to attack our political opponents. Our constituents deserve better than they've gotten. And we can start by fixing this today and doing what really ought to be done in this particular area. So I want to thank you three gentlemen for appearing and the other witnesses as well, and just say that I hope that we can be fair in these matters and treat the Trump administration just as fairly as we want our personal interests to be treated. Thank you, Mr. Chairman.
Thank you, Senator Hatch. I appreciate your remarks, Senator Whitehouse.
Thank you, Chairman. Gentlemen, welcome. I will try to move through my material quickly to obey the Chairman's injunction that we move along. First, do any of you have any doubt whatsoever that Russia interfered in our 2016 presidential election? None. Okay. Just to be clear.
Well, let me just say, I only know what I've read in the newspaper. I'm not involved. We're not involved.
Understand. It's not because you're the IG.
Yeah.
So the Foreign Agent Registration Act, you will all agree, I hope, has as its purpose to identify foreign agents seeking to influence U.S. government policies, correct? Correct, yes.
Correct.
Is that an important purpose? How important a purpose, in very brief words?
Very important, Senator.
Agreed.
Agree.
Can foreign agents seeking to influence U.S. government policies use shell corporations to obscure their identities?
Senator, I can certainly conceive of situations where agents acting here for a foreign principal could use corporate forms or other measures to hide the connection to the principal.
And the use of non-transparent corporate forms, does that help or hinder your ability to investigate foreign influence in U.S. government policies?
It would be part of the challenge I referred to earlier, Senator, of the difficulty in proving direction or control to the ultimate principal.
So greater transparency as to who is behind a shell corporation would be an advantage to law enforcement.
I think so, Senator, yes.
Similarly, could foreign agents use anonymous political contributions, say through 501c4s or through identity laundering devices like Donors Trust, to obscure who is actually making the political contribution?
Senator, I'm not so much an expert in campaign finance or contributions. What you've said sounds right to me, but I don't want to mislead you that I have any particular expertise in that
Let's put it
area.
this way. If your purpose is to identify foreign influence being brought to bear on our government, and election money is pouring in, and you don't know who is actually behind it, that creates an avenue for foreign influence to influence our government, correct?
That sounds right to me, Senator.
Can business relationships be used, and indeed, is it not well established that Russia tries to use business relationships to facilitate or as cover for foreign influence operations?
I'll defer to the FBI to speak to Russia specifically. I know that one of the challenges, Senator, that we face is that there's often an economic or commercial cast to the activity here, but in fact, the foreign government may be the principal beneficiary, or the activity may not be private or non-political in nature, and thus require registration.
And it's established through both the Kremlin Handbook report by CSIS and the Kremlin Trojan Horses report by Atlantic Council that Russia actually uses business relationships to corrupt and to influence people in other countries where they're seeking influence, correct? Mr. Priestap, you're familiar with that?
I'm familiar with both reports, and in my experience, that is true.
So, in an investigation into a foreign agent's efforts to influence U.S. policy, being able to understand business relationships could be vital to understanding the influence scheme, correct?
Absolutely.
And in that effort, are an individual's tax returns potentially very significant, indeed often obvious, investigative material?
A variety of financial records pertaining to any of the individuals or entities involved could be of importance, but
including tax returns.
Including tax returns.
Which are so widely pursued in criminal investigations. There's actually a whole section on the U.S. Attorney's Manual devoted to the simple process for investigators getting access to tax returns, correct?
Yes, I'm not an expert on tax returns, but they can be of investigative value.
Thank you very much. My time has expired.
Senator Cornyn and then Senator Klobuchar.
Thank you, Mr. Chairman, for holding this very important hearing, and I hope some of our Democratic colleagues who have objected to the continuation of this hearing beyond 2 hours will reconsider and withdraw that objection, because what we're doing here is simply too important to the security of our country. Mr. Priestap, thank you for making what I think is a really important point. We tend to focus on the trees instead of the forest. And here, of course, the immediate concern is about Russian involvement in our elections. But you've made the point, I believe, that that our international adversaries will use a range of activities, both overt and covert, to undermine us in a variety of ways. And of course, now we're just talking about the Foreign Agents Registration Act, which would be more of an overt means of doing so. But I fear that FARA violations are happening around this town all the time, meaning foreign governments are attempting to exert undisclosed influence over U.S. policy, and we simply don't know about it. I experienced this recently in my work on the Justice Against Sponsors of Terrorism Act, which is a law that gave Americans tools to fight terrorism and bring justice to victims that had the overwhelming support of Congress, notwithstanding the veto of President Obama. Opponents of the bill warned that any number of consequences would occur with our relationship to Saudi Arabia, which was not named in the bill, but of course none of those have resulted. But even though they were wrong, the debate was a real one and the kind that ought to accompany any bill. But along with healthy debate, the Kingdom of Saudi Arabia reportedly undertook a cloaked campaign to gut the legislation. It involved ghost-written letters and ghost-written legislation, involved threats to American companies. It involved, as of October 2016, Saudi Arabia paying American lobbyists and public relations firms to undermine or overturn the legislation. They paid them $1.3 million each month to fight against the right of American victims of terrorism to sue terror financing nations. But the worst part of this campaign was the use of veterans to persuade members of Congress. According to press reports, agents of the Saudi government recruited American veterans, flew them to Washington, wined them and dined them, and then put them up in fancy hotels and provided them with false information to provide to members of Congress. They didn't tell these American heroes that who was sponsoring them and who they were serving. And not only did these agents apparently violate FARA, they put our American veterans at legal risk. Veterans indicated the organizers concealed the sponsorship of their trip, and a number of the firms did not file under FARA until outraged veterans and press reports revealed those activities. This kind of conduct should gall every member of the Senate, and it demonstrates that foreign nations will pay large sums of money and go to great extent to influence our laws and policies of the United States government. Unfortunately, they can do so nearly unchecked and with little threat of punishment, and that must change. Gentlemen, I'd like to ask you that when the Lobbying Disclosure Act was implemented in 1995, there was a corresponding drop in Foreign Agents Registration Act. Current law allows an individual who represents a foreign individual or commercial entity, but not a foreign government or political party, to register under this Lobbying Disclosure Act instead of the Foreign Agent Registration Act. And of course, there are instances where companies are either formally or informally controlled by foreign governments. We can think of a number of them. And there's an open question of the level of government control of any company in China, for example, which is all subordinate to the Communist Party and the government of China. So I would ask each of you to comment, should the Lobbying Disclosure Act be amended so that all foreign commercial entities would likewise file under the Foreign Agent Registration Act? And how do we handle the fact that many foreign nations use state-owned or state-affiliated enterprises to conduct their foreign policy? Should we think about FARA in that light as well? So, in your opinion, how large is the community of U.S. companies, or enablers, as they're sometimes called, searching to find clients interested in avoiding FARA? I know there are a number of questions, but I'd be interested in your brief comments, given the considerations of time.
Senator, I'll be as succinct as possible. Repealing what we call the LDA exemption is, I think, in one of the proposed pieces of legislation I referred to earlier. I can't take a position on it today, but I hope to have coordinated administration views on that question later. I know two things from managing the FARA unit's work. One is, as you pointed out, the number of FARA registrations dropped precipitously shortly after LDA was passed and this exemption was passed. And at the time, the department expressed the view that might happen, that the exemption should work a different way, that you maybe would be exempt from the LDA, but not FARA in this circumstance. And one of the challenges, the last point I'll make quickly, is one of the challenges we face is that the companies may not even be controlled, or at least not on paper, by the government. They may, in fact, be just a well-connected corporate enterprise, not under the direction or control of a foreign government, but whose interests overlap and who, under our regs, are doing work, the principal beneficiary for whom is the foreign government. Those folks are still obligated to register. So we search the LDA database and try to find those potential registrants and ferret out whether the principal beneficiary is really the government or political party. But it's a challenge for us, sir. Thank you.
Senator Klobuchar.
Thank you very much, Mr. Chairman. Thank you to you and Senator Feinstein for this hearing. And while it's disappointing that some of our witnesses aren't here today, it is important to move forward in a bipartisan way. And I'm going to focus on the issues at hand here. Mr. Hickey, I am a co-sponsor of bipartisan legislation, the Foreign Agents Registration, Modernization, and Enforcement Act, to give federal prosecutors the civil investigative demand authority they need to investigate foreign entities and help ensure that they comply with the law. Under the bill, the Justice Department could make suspected FARA violators turn over relevant documents before initiating a civil or criminal proceeding. And I understand that obtaining this authority has been a priority for the Justice Department's National Security Division. Can you explain why this type of authority would be so helpful to prosecutors?
Thank you, Senator. As I mentioned earlier, I'm not in a position to call for any particular legislative change today. I simply don't have authorization to do that. But as I think you've noted, twice in the past, I think in 1991 and about 1998, the federal government has proposed CID authority for NSD for exactly that purpose. And so while I won't advocate one way or the other today, I'll simply point out that that authority would create a middle ground between resorting to a criminal subpoena, which you wouldn't necessarily have the basis to do or be in the right position to do, and the voluntary letter of inquiry that we rely heavily on now.
Okay, thank you. And then a more detailed question on Russian TV. We know our intelligence agencies have found that Russia tried to interfere in our election. In January, the Office of the Director of National Intelligence released a report documenting some of the ways they tried to do this, including through news outlets. And they say that RT America was explicitly set up to avoid the Foreign Agents Registration Act because it's registered as a nonprofit instead of a government affiliate. Can one of you, Mr. Hickey, Mr. Priestep, can you elaborate on why RT is not currently registered under FARA?
Senator, I probably shouldn't comment on any particular individuals or entities, but it strikes me that when Congress passed FARA or amended it recently, maybe in the 60s, this is when this changed, or the 40s, it deliberately carved out U.S.-owned media organizations. It was very precise about that. So what that tells me as a prosecutor is that that intended to capture potentially others who are not U.S.-owned.
Or not.
So I'm familiar with the reporting you've referred to, and I'm familiar with that provision of the statute.
Very good. Well, it would be good if we could pursue that line if, in fact, the statute says that they've carved out a U.S.-owned from foreign-owned, and obviously it might not just be Russia, it could be another government as well. Do you think, this is just to the panel, whoever wants to take this one, do you think that the FARA requirements in current law adequately reflect recent technological advances, or would additional requirements such as clarifying FARA social media disclosure standards and updating the 48-hour rule for Facebook and Twitter help the FARA unit do its work more effectively? I know you can't comment on exact legislation, but are there tools that could be out there that could be helpful to you?
Thank you, Senator. I think the internet does present a challenge for us because the statute is limited to individuals acting within the United States. I know as early as 1940, the Attorney General, then Attorney General, issued an opinion that if you mail materials into the United States, even if you're not here, you're acting within the United States. So I see the challenge with the internet as both a technical one, but also a question of jurisdiction. Even if you're, quote unquote, subject to FARA because you're acting here, how will we reach the agent who is physically located in another country? I see that as a significant challenge.
Okay. Do you want to add anything, Mr. Priestep, for any of my questions?
No, I just think Mr. Hickey's exactly right, and that is the true challenge, and I'm not certain how you legislate that.
Okay. Anything, Mr. Horowitz?
No, I think the internet presents some new challenges, and thinking that has to occur on the 48-hour rule and other requirements.
Mm-hmm. It just seems like we may need to update this law in light of everything that we've seen, given that another election is around the corner and everyone in America wants to have their vote count, and that means not having influence from other entities. So I want to thank you very much.
Thank you, Senator Klobuchar. Now, Senator Lindsey Graham.
Thank you, Mr. Chairman. I'd like to add my compliments to you and the ranking member for conducting a very organized way forward in terms of dealing with the threats we face as a nation and changing our laws consistent with those threats. I am too disappointed that we have a 2-hour rule on something that's important. 2 hearings I know have been canceled because we can't agree on health care, but we should be able to agree this is important. Mr. Browder's got a lot to say. So here's the deal. AIPAC, are you familiar with AIPAC? American Israeli Political Action Committee.
I have heard of it, sir, yes.
Okay. They come up here in droves, lobbying Congress to do things, in their view, good for the U.S.-Israel relationship. I know they have a lot of contacts in Israel. Should somebody like that be a foreign agent?
Sir, it's probably not appropriate for me to comment on a particular entity, but I think you've hit on something very important to us, which is right now we rely principally on public reports for the basis to send voluntary letters of inquiry. I would love to receive more information in whatever form anyone can give it to me about what's occurring behind closed doors so we are able to take steps to investigate if appropriate.
I'm not suggesting AIPAC's doing anything wrong, quite the contrary. They're a group of Americans who've banded together to maximize their influence to speak about something important to them that involves a foreign ally. So I think the AIPAC model is a good thing, and that's not my concern because they're very transparent. They have conventions, and we all know how the game's played there. So I just want to make sure that lobbying on behalf of a foreign government or a U.S. relationship with a foreign government is not a bad thing as long as you do it right. And I have some friends of mine who represent foreign countries that come into my office all the time talking about the country's view of whatever we're doing. Nothing wrong with that as long as you're up front. An example of what would bother me, General Flynn, who I admire his service to our country, but he wrote an op-ed piece saying that we should extradite Mr. Golan, the guy that Erdogan hates so much. I didn't know at the time that he was receiving hundreds of thousands of dollars from a group that was representing Turkey. That's the kind of thing we want to get a hold of. Is that correct, Mr. Hickey?
We did advise General Flynn that we believed he had a registration obligation, sir.
Okay, but that kind of conduct is what we're all worried about.
Or may have, I should say.
May have. So let's get back to what Senator Klobuchar was talking about. You've got Russian bots that are actively pushing fake news and news helpful to one candidate, harmful to the others into our political system. So you got all these Russians sitting around making up crap and sending bad articles to key districts to influence outcomes of an election. This time it may be against the Democratic Party. Next time it may be against the Republican Party. Next week it could be Iran or North Korea. It goes on and on. What happens, or what power do we have if somebody in the United States coordinates with them? Some platform or website begins to coordinate with content that originates outside the country, being disseminated in a political fashion within the country, if somebody coordinates with them or becomes an ally, what status would they have?
Senator, I'd have to look at all the facts and circumstances of a particular case. FARA reaches conduct when the person acting within the United States is doing so under the direction or control or as the agent of the principal.
What, in this circumstance, the generated content is coming outside the country, is being delivered in the country for a political purpose, and any American or organization within the country that colludes with them, for lack of a better word, should we have laws that deal with that?
Under FARA, I think one question you'd have to ask, Senator, is whether that person here is acting as the agent or under the direction or control of those foreign individuals.
If they are, should they register?
That's one of the principal pillars of FARA, is that if you're an agent acting under the direction or
Do
control.
our laws give a good enough answer to my question, or should we change our laws to deal with what's the reality of the future?
Senator, I don't feel prepared to answer that question today. I'm sorry.
Thank you.
Senator Franken and then Senator Kennedy.
Thank you, Mr. Chairman. Thank you, gentlemen, for testifying. In January, the Director of National Intelligence released a classified report detailing interference in last year's election. The report states unequivocally, quote, Russian President Vladimir Putin ordered an influence campaign in 2016 aimed at the U.S. presidential election. Mr. Hickey and Mr. Priestap, you're here today representing the Justice Department's National Security Division and the FBI's Counterintelligence Division. Have you read the declassified intelligence assessment of the Russian operation?
I have, Senator.
Thank you.
I have as well.
Good. Have either of you read the classified version of the report?
I have.
Okay, thank you.
I'm not sure, sir.
Okay. Do you have any reason to doubt the intelligence community's assessment that the Russians interfered in last year's presidential election?
No, sir.
No, sir.
Well, for some reason, President Trump remains unwilling to accept the fact that Russia interfered in our election. We saw this during the campaign when he dismissed reports of Russian meddling by suggesting that the hacking could have been carried out by, quote, somebody sitting on their bed that weighs 400 pounds. But now, 6 months into his presidency, we continue to see that reluctance to acknowledge the truth. Just last week, the newly minted White House Communications Director, Anthony Scaramucci, appeared on CNN. He said this, quote, you know, somebody said to me yesterday, I won't tell you who, that if the Russians actually hacked this situation and spilled out those emails, you would never have seen it. You would have never had any evidence of them, meaning that they're super confident in their deception skills and hacking. The host of the show asked just who that somebody was, and Mr. Scaramucci admitted that it was President Trump, who had explained that if the Russians had, quote, hacked this situation, that the United States would not have evidence of that hacking because of the Russian superior intelligence capabilities. Do either of you know where President Trump got that idea?
No, sir.
No, sir.
Well, I'll tell you. President Trump believes that to be true because Vladimir Putin told him so. The New York Times later confirmed that Putin was the source of that information. The Times reported that President Trump emerged from his meeting with Putin to, quote, tell his aides that the Russian president had offered that Moscow's cyber operators are so good at covert computer network operations that if they had dipped into the DNC systems, they would not have been caught, unquote. Now let that sink in for a moment. The President of the United States is taking the word of Vladimir Putin over that of our nation's intelligence agencies, which demonstrates a a stunning lack of confidence in the men and women who put their lives on the line to keep us safe. And the President of the United States then goes on to repeat that Russian lie to the American press and to Mr. Scaramucci, effectively spreading Russia's misinformation for them. Mr. Priestap, you have experience in counterintelligence. When then FBI Director Comey appeared before the House Intelligence Committee in March, he described the Russian operation as, quote, unusually loud. He said, quote, it's almost as if they didn't care that we knew. Their loudness, in a way, would be counting on us to amplify it by telling the American people what we saw and freaking people out about how the Russians might be undermining our elections successfully, unquote. Do you agree with former Director Comey's assessment? Was the Russian operation unusually loud?
Yes.
Mr. Hickey, you manage the National Security Division's efforts to fight cyber attacks. Do you agree with Director Comey's assessment, former Director Comey's assessment?
In my position as a lawyer, sir, I would defer to Director Comey on that question and the FBI.
Let me just, can I have a few seconds? So it seems fair to say that not only did Russia interfere in last year's election, but that Russia likely wasn't trying to fly under the radar. Contrary to what Putin may have told President Trump, it would seem that Russia actually wanted Americans to find out about its efforts, that our knowledge of their operation and the unease it continues to cause us was in fact central to undermining Americans' faith in democracy. Thank you for your indulgence,
Okay.
Mr. Chairman.
Senator Kennedy.
Mr. Chairman, are we going to get to Mr. Browder today?
We will we'll stop here at 11:30 as the rule requires, and then Mr. Browder will be here tomorrow at 9 o'clock.
Okay.
We'll recess the hearing till 9 o'clock tomorrow.
Okay. And that's because of the 2-hour rule?
Yes.
I'd like to join Senator Graham and Senator Cornyn. I'd like to know who invoked the 2-hour rule. Certainly they're right, but I think they owe it to this committee and to these witnesses, some of whom traveled a long distance to explain their reasoning.
Yeah, and he came from overseas to be here.
And has to stay now an extra day.
He's willing to stay. And I don't know why the 2-hour rule was invoked, but if it was invoked so we couldn't talk to Mr. Browder, it can happen tomorrow at 9 o'clock. So we can overcome if that's the rationale.
Well, if Mr. Browder's here, I apologize for that.
I think he will be in the ante room if you want to apologize.
Okay, I will do that.
Yeah.
Mr. Hickey, according to media reports, Mr. Sidney Blumenthal lobbied former Secretary Clinton to show support. He was asking Secretary Clinton to show support for a prime minister candidate in the country of Georgia. According to media reports, Mr. Blumenthal allegedly passed along personal letters to Secretary Clinton from the leader of the opposition party and transmitted a memo, allegedly, to her from an acquaintance by the name of Mr. John Kornblum. The letter urged Secretary Clinton to support the same opposition party in the Georgian elections. According to media reports, and I guess you could check as a matter of fact, neither Mr. Blumenthal nor Mr. Kornblum have registered under FARA. And I'd like to know why DOJ has not required them to register.
Thank you, Senator. Unfortunately, consistent with longstanding Department of Justice policy, I can't confirm or deny or comment on particular individuals or entities or investigations or potential investigations.
Okay. You ever heard of a group called Fusion GPS?
I have, sir.
I think its co-founder is Mr. Glenn Simpson.
I have seen that in media reports, sir.
Has he registered under the statute, FARA?
I have not searched for his name, sir, so sitting here today, I don't know for sure. I think the answer is no, but again, I'm not sure. It's public.
Well, has anybody at the Department of Justice searched for his name?
I don't know that, sir.
Is somebody looking into that?
I can't comment on that, sir.
General Horowitz, why, I think you testified that 2 decades ago, enforcement of FARA became less of a priority. Why was that?
Well, what we saw was about two decades ago a significant drop-off in the number of filings. And one event was the 1995 Lobbying Disclosure Act, but actually preceding that by 2 years was the imposition of fees for filing. And if you actually look at our report and the chart we've done and the graphic that we've included in the report, it shows the cliff actually starts occurring in 1993 after fees were imposed. And one of the challenges we had when we went in and did our audit was trying to determine what was the impact of the Lobbying Disclosure Act. And the problem we had was there really had never been an assessment done by the department and the folks administering the program to determine if that was in fact the cause, as opposed to a
What do you
supposition.
think? You've studied this issue, General. What do you think the cause was?
It looks to be a combination of both, potentially, as well as we talked about earlier, the need to have a strong enforcement policy and a mechanism to ensure that folks out there understand there are real consequences to failing to register. And I think one of the concerns our team had and I had in looking at this is in 50 years doing 7 criminal cases, 5 of which result in convictions and 3 of which involve FARA charges over a 50-year period doesn't necessarily send the message out there that there's real teeth behind the statute.
Well, I'd like you to think about this, too, to let it sink in, all 3 of you. What you allow is what's going to continue.
Okay.
Now, I understand that the Justice Department can't talk about investigations, and I respect that, and I think it's a good rule. But General, I hope that you will continue to monitor this, because it's clear that there's been a failing, and I don't know what metric we have to understand whether it's been fixed.
Yep. No. We will do that.
Thank you, Mr. Chairman.
Senator Hirono, if you use your 5 minutes, then I got to inform Senator Cruz you might only have 2 or 3 minutes for you, and then we'll 2-hour rule we have to turn. Senator Hirono.
Thank you, Mr. Chairman. Mr. Hickey, despite conducting significant lobbying on behalf of foreign pro-Russian interests, Donald Trump's former National Security Advisor, Michael Flynn, and former campaign manager, Paul Manafort, only filed with FARA after their activities were publicly disclosed. Doesn't that undermine the purpose of FARA?
Good morning, Senator. Unfortunately, I can't comment on particular cases. What I will say is we do our level best to identify conduct through every source we can and act on it by sending either a voluntary letter of inquiry or opening a criminal case.
So regardless of whether you can comment on particulars, I'm getting to the delay in registering under FARA, and I'm wondering whether a delay in registering at some point can amount to a willful violation of FARA.
You can see.
I think that's a good question, Senator. The statute makes clear that if you register late, that does not preclude a prosecution. And there may be a number of facts that raise an inference of willfulness. Yeah. Certainly, the goal of the statute is to ensure that that agents register immediately, essentially, upon becoming agents of principals, or I think it's within 10 days. That is what the statute demands.
So perhaps we need to strengthen that part of the law, because I think at some point you mentioned that there needs to be a showing of willfulness and to show a violation of FARA. And I would say that substantively, at some point, a delay in registration amounts to a willful violation. Further question. During the 2016 Republican Convention, the Trump campaign insisted on a change to the National Republican platform, making U.S. policy on Ukraine much more favorable to the Russian government. At that time, Paul Manafort was the Trump campaign chair, and at that time he had been paid $17.1 million in unreported payments from the Party of Regions, the pro-Russia party in Ukraine. He had also had extensive business dealings in the Ukraine and with wealthy Russian oligarchs, yet he did not register under FARA until this year and never disclosed this work. Wasn't this the kind of activity on behalf of a foreign government that FARA registration is meant to disclose?
I'm sorry, Senator, I don't think I can answer that question. We had previously advised Mr. Manafort we believed he had an obligation to register, and he is registered.
I think that answers my question. Would this raise any red flags for you or your investigators, Mr. Priestap?
I'm sorry, I can't comment on that.
You can't even comment on whether or not an action, let's just take out the names. If somebody did this, wouldn't this raise red flags for you?
I'm sorry, I just don't want to comment on any individuals or entities or fact patterns associated in any way with potential or current investigations.
Would it be fair to say that this kind of fact pattern where there's non-disclosure or non-registration, that this is not necessarily unusual? And so this happens, you know, we have a concern in this committee that there be the enforcement of FARA and whatever may arise out of a violation of FARA. So regardless of whether you can comment or not, I would hope that the FBI in this kind of factual circumstance would look into what is going on. There's been some discussion about the what happens with the LDA and the fact that there's been such a decrease in registrations under FARA as after LDA. I'm wondering whether that, Mr. Hickey, you said that the DOJ searches the LDA databases for people who may not have appropriately registered. So my question for Mr. Priestap is, does the FBI search the FARA databases for potential violations of law?
Not that I know of, ma'am.
Why wouldn't you?
We depend on the Department of Justice to, in effect, oversee this area. It's, as Mr. Hickey I believe mentioned previously, this is a regulatory or a disclosure statute. It is not a criminal statute, and Department of Justice is mainly responsible for the administration of it.
Well, it's just we understand that FARA is merely a disclosure law, and it is the FBI that gets into any criminal activity. And since FARA requires a lot more disclosure than the LDA, well, one would think and hope that the FBI would pursue looking at the FARA databases. So it's an editorial comment. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. And let me echo the concerns that a number of folks have raised, that I think it's unfortunate that the Democratic angry resistance has extended to the level of obstructing nominees across the board and now shutting down committee hearings, as this one will be shut down in 2 minutes. I think that is unfortunate. You have senators not willing to do the jobs they were elected to do. In the minute and a half we have, Mr. Horowitz, your office conducted an extensive review of the National Security Division. This included a review of the enforcement of FARA, or perhaps is more accurately described, the non-enforcement of it. In your opinion, is non-enforcement a result of a conscious decision or merely a lack of coordination within the Department of Justice?
Well, what we saw was a lack of coordination, and that concerned us, and the fact that there were a handful of cases over a 50-year period raised concerns for us about what message that was sending to the community out there that should be registering voluntarily.
Now, if it's a lack of coordination, where is the process breaking down?
Well, we saw very different opinions among AUSAs and agents and the NSD over what it meant to handle these cases. And I think, as was just mentioned, the National Security Division, as the attorneys responsible for the regulatory scheme, really has to take the lead on coming up with an enforcement strategy, coordinating with the FBI to move forward to make sure that folks are registering voluntarily, and if not registering voluntarily, that there are cases and investigations that result from that.
Now, the FARA registration unit focuses on voluntary compliance, and yet there are U.S. attorneys' offices that are bringing criminal matters. What explains that differential?
Well, the U.S. attorney's offices are seeing the failures to file, are looking at these cases, and believe there are willful failures to file, and that was, again, a point of dispute. With the oversight that was going on with the National Security Division of those cases, they need to, at the NSD, approve those cases. in order for them to be brought. And we heard from AUSA's concerns about that, how that was going on reviews of evidence, concerns about jury appeal, that prosecutors thought they were in the best position to determine based on their districts and what they knew about their districts. And that was an area of concern for us, that there would be that kind of a dispute between prosecutors in the field and folks at Maine Justice.
Thank you, and I think the committee's time has now expired.
The 2-hour rule goes into effect right now. I thank all of you for participating, and the hearing will be recessed tomorrow, and we'll hear from start out with Mr. Broderick. It'd be 9 o'clock tomorrow if I didn't make it clear. Yeah.
Well, the president took to Twitter today to announce that he'll ban transgender people from serving in the U.S. military. The president wrote, "After consultation with my generals and military experts, please be advised that the United States government will not accept or allow transgender individuals to serve in any capacity in the U.S. military." President Trump said that the military cannot be burdened with the tremendous medical costs and disruptions transgender troops would require. We'll likely hear questions about this during today's White House briefing. It'll be live on camera beginning at 2 p.m. Eastern, and we'll have it here for you on C-SPAN.